have a court order. I mean, just as you would a search warrant, somebody which a magistrate can issue, you would have someone who refuses to comply with the search warrant could theoretically, and probably beyond theoretically, could be charged with obstruction of justice, taken into custody, and compelled in that particular fashion.
Okay. If you note or you just note your appeal of the order through the district court, you're waiting until the district court comes back the following week, whenever.
That is a safeguard that is in the existing system. I mean, anything that we can do to make this happen quicker, for the officer's sake.
I agree.
It's, you know, but there are obviously the way the bill is drafted, the amendment is drafted, there are still procedural safeguards.
I just don't want to remove any safeguards. I'm trying to. I like the appeal to circuit. Now, if it's being removed, I'm kind of.
Well, that appears to be a policy decision. I don't know of no reason why you couldn't have an appeal from general district to the circuit as well. Appeal to no vote.
Okay. All right. Mr. Chairman, can I move that amendment in concept and ask the paper if she's okay with that? Oh, I'm sorry, you're taking this up. You can take bucks to be the delegate. You're the one we care about.
We would be friendly to that.
Okay. Make that amendment. Is that something staff can do on the fly, or is this a next meeting kind of thing? Oh, see, this is courts. Welcome. We love you so much. We want you to come back and back. Okay. So, Delegate Price, we're going to pass it by for now.
Okay.
I would suggest if you want to go get a cup of coffee or something,
Or go for the
come back, and then but come back, or else you'll be stuck here with us another day.
Okay.
All right. Very good.
Thank you.
Yep. Okay. All right. So we're going to do some bookkeeping. I think we can do bookkeeping without. So, okay. So we've had several patrons ask to help strike the bill. Delegate Mr. Cotter, if you can make sure I don't mess up the numbers. House Bill 70, Delegate Weber, and that's a strike. So we've been requested the patron strike House Bill 7, Delegate Weber. Can we get that second? All right, you can put that on the board. No, because these other bills are not done. I'm sorry. Right. The motion is to strike. Everyone will cast their vote in the electronic voting board. Clerk will close the roll. Delegate LaRock has asked us to strike House Bill 492. Okay, second, all in favor of striking House Bill 492, cast your vote in the electronic voting board. Second. There we go. Okay. Next one's a little more complicated. House Bill 984, Delegate ENC. It involves the prostitution of minors and the steps you could take so that they don't get convicted. We had a similar measure for consideration for adults, and we sent it off to the Crown Commission with a letter. And so I've spoken to the patron. He thought that was a fair resolution for that, and this was in the Vincent wheelhouse. So what I would ask the staff member, if we tabled or PBI that, what do we do? PBI. Okay, so I'll entertain a motion to PBI, and we can add that to the letter that we're sending to the Crown Commission on House Bill 984. Is there a second? Second. All right. Well, you can put PBI out. Everybody, what we're doing is you're trying, if you happen to be here for one of these bills, you want to make sure you hear about this quickly so you can go home. All right. Delegate Hugo had an expungement bill, 1214, that he understands that we addressed all the other expungement bills, reminding the other members to my left that you might have voted in the other direction on this, so this may not be a unanimous vote. But it's House Bill 1214. Yeah, he understands it's going to be PBI. Second. All right. You may well have voted the other way, Vivian. I'm sure. Okay.
He has requested.
No, I don't. I'm saying he understands what happened. He understands what's going to happen. He's not asking us to rehear the 1.5-hour hearing. So, if you're trying to be consistent with your previous votes, I think you would vote no. This is not a motion to strike. This is the one that was pulled out of the expungement block, and I told him what happened and said that was going to happen anyway. consistent with your previous votes, you may want to vote no, sorry, okay. We had Price we just heard. Let's look at Delegate Hope's, please. So Delegate Hope has asked us to see if we can do this in his absence, and my understanding is from staff, it's a very simple bill. If it's not, we will stop taking it up in his absence.
Make that as a challenge.
Okay, so I would ask Council, Mr. Lentnick, if you would tell us the bill, and we'll otherwise treat it like a normal hearing.
Mr. Chairman, House Bill 88 adds to the use of field tests for the identification of controlled substances, the ability to use them in a misdemeanor possession with intent to distribute marijuana trial. Current law is that the field test is only admissible in the trial of possession of marijuana charges and in preliminary hearings for felony charges. This would add the possession with intent to distribute misdemeanor that's less than 1/2 ounce marijuana to that law, allowing the use of that so that a lab certificate was not necessary. It retains the provision that if the defendant wishes a lab test, they can make that request and the court has to order the lab test.
And so this is misdemeanor district court, obviously it would be appealed, but this will be a district court case, just like the simple possession cases often are.
That's correct, Mr. Chairman.
Okay. Any member of the public like to be heard on House Bill 88? You have an invisible Patrick Hope here? Okay. If this is anything other than unanimous, we will take it by, but if it's ready to go. Sure, okay. So when somebody's expressed some concerns, let's pass that by until Delegate Hope can get here, and then we'll take it up with more people. Okay. Can you see if Collins is available? Because we're running out of stuff. We're running out of bookkeeping. It's a consistent project. We're trying to organize this docket in a sensible way so we get to most people in the shortest time. Those copying out, it's like a horror movie, people leave one by one. Is it- That's what I was saying.
It's like a horrible scene in a movie.
Maybe you want to take yours by for the day, or do you have an answer? Have we decided? I'm just trying to move the merchandise.
Since I'm 99% sure that this will be the answer that would come back from my copy, we're dealing with House Bill 307, which was a fairly long saga about what the offense is if you don't obey, no soliciting sign. I'm sure, I think the answer that will come back from my Commonwealth Attorney, Ray Morrow, who suggested this to help protect the elderly who are being preyed upon by contractors, that he will understand that we have found that there's been more than a few, I think at least a half dozen local ordinances that have been passed to deal with this issue, and there's been no challenge of the local authority. In fact, it goes with the local authority to protect the public, and so with that, I don't want my bill to get in the way of those local efforts, and therefore would strike my bill and hope that my county, if not my whole region, will pass similar ordinances so that these predatory contractors, we at least have one handle to make an arrest as they try to prey upon people who make poor witnesses when we can finally bring them to trial for all the tens of thousands of dollars that they may have fraudulently taken. Thank you for allowing me to speak. With that, I strike the bill.
Okay, so Delegate Watts has moved, and I get a second. Second, okay. Move to strike her bill, House Bill 307, the solicitation measure. All in favor? We'll cast a vote in the electronic voting board. At this point, the Republicans are brutally, oh, there we go. Thank you. Close the roll. strikes again in case, or the bills that are no longer going forward, in case you're sitting here waiting for that to be heard. We have now addressed and will not be proceeding any further with House Bill 70, House Bill 492, House Bill 984, House Bill 1215, and House Bill 307. If you're here for just that bill, you're free to go. Good to go. Okay. Delegate Collins, are you here?
I am.
Okay, so we have a block of bills. A block of bills involving various aspects of distracted driving. And what we would typically do would be to, Delegate Collins has done some work on this. He'll present some work that he's done. We'll take a period of public comment, both from other patrons and then members of the public. There's other bills that present parts of this which are not related, like Yancey's. I'm afraid you'll just have to wait. And then the committee will just do some work. So, Delegate Collins, you've been working on this for a few days.
So, as a work group with law enforcement and the like, to try to come up with some language to tighten up what is now or currently texting while driving, we've come up with, I think, HB 181, which I believe there's going to be a substitute handed out. Right, so that's the most recent one, yes.
So, Delegate Collins, I think we know at least the problem. It's not our first hearing, but if you would express what the problem you're trying to fix is.
So, obviously, we are dealing with the texting while driving statute that we have currently on the books is not being used. It's very difficult to prosecute. You basically have to have someone confessing to texting while driving or getting a subpoena to able to get into their phone and see if they've actually been texting. We have heard lots of complaints from prosecutors and from judges who say that all someone has to do is say, I was not texting, I was using my GPS, or I was doing Facebooking, apparently, and so our texting while driving statute didn't cover those things. So in an effort in this off-season, what we did was we looked at another way to add some teeth. We avoided, there is a bill 180, which is under reckless driving, but the reckless driving statute still applies if you are endangering people's lives. So what we've done is we've created a carve-out under improper driving, which is a standalone for handheld devices and distracted driving. So what you're reading now, as that is a separate and apart from the current improper driving, and it is a standalone improper driving statute. So we discussed why this bill is important, but I want to make sure everyone kind of understands what it is that we're doing.
Mr. Chairman.
Delegate Klein.
Pedro just said it was a standalone improper driving and distracted driving.
It is, but it's if you look, it's .1. I don't have a copy of the current version in front of me, so.
So 869 is improper, this is 869.1.
Right. So if you look at 46.2-869.1, that is now its own code section, whereas 869 is still improper. So if an individual is reckless driving, they would still have the ability to find improper for other circumstances. But this gives law enforcement probable cause now for someone who is driving while distracted, and it's an improper, so it's a fine rather than any jail time. And
Okay. All right, so what I would next suggest, Delegate Collins, if you would actually sort of take a seat next to people, we're gonna probably hear a fair bit of testimony now. So we have several other patrons who have had ideas. Okay, let's go ahead and, I see Delegate Bell, Delegate Mullen, Delegate Ayala, Weber, Yancey. Anyone who has had ideas in this wheelhouse, go ahead and come up, tell us the ideas in your bill, because we're not going to bring 7 bills out of this subcommittee, but at least we can use ideas that we like.
Chairman.
Bell.
I appreciate, with so many bills, the idea of bringing together one good bill. My bill is a little bit different, House Bill 177, because it basically prohibits the vehicle operator from using his hands to use a handheld personal communications device while driving. It's a hands-free bill, technically. It does have carve-outs for emergency vehicle operators. It has a specific carve-out for what we call ham operators, who often use their equipment in disaster situations. The other thing that's different in my bill that I don't know, I don't believe it's included in the omnibus bill that's trying to be put together here, is driving with an animal prohibited. And there is an amendment in the nature of a substitute. I don't know if you'd like to act on the substitute, or if it's going to go that far, frankly.
So we can use your most current language. Thank you.
And that portion of the bill simply says that no person shall operate a moving motor vehicle with an animal on his lap, permit an animal to impede his free access to and use of vehicle controls while operating a moving motor vehicle, or permit an animal to obstruct his vision while operating a moving motor vehicle. And basically, it's another distraction for the reasons that Delegate Collins mentioned at the front of his presentation here. Enforcement of the current law is very difficult for law enforcement personnel. I think if we narrow the scope to hands-free, it's a lot easier for law enforcement to tell if someone's using that phone. And right now, it leaves the door open for a lot of things that this would eliminate, I do believe. So that's the gist of it, Mr. Chairman, and I appreciate it.
Okay. Thank you, Delegate Bell. Delegate Roberts.
Thank you, Mr. Chairman. Mr. Chairman.
Hold on, being distracted. Phone. Go ahead.
What? Sorry. I just crashed. No, Mr. Chairman, I had 116, and if I could, I'd like some representatives from my county sheriff's office are here, and this particular bill came at a request from my county because what the bill did originally was it authorized local governing bodies to adopt an ordinance prohibiting a person from driving a vehicle on a highway within a locality while failing to provide proper time and attention necessary, essentially an improper driving for the safe operation of a vehicle. The bill provided a violation of such ordinance is punishable as a traffic infraction with a fine of not more than $300. And Mr. Chairman, this bill came out of Fauquier County because they are in strong support of this legislation, because on Route 29 and a couple other routes that we have, if I could get these guys to come forward, we've had a number of fatalities, and it's not per se that it's distracted driving, it's phones, it's et cetera, but our localities, and Loudon was here in support, Sheriff Chapman was here in support as well. They've kind of launched a program with signs up all around our county that say you can wait. The other thing is that a recent opinion of the Virginia Attorney General restating and upholding a prior AG opinion, finding that there are Virginia localities that do not have the authority to adopt local ordinances, and Sheriff Chapman can provide some more details, but there are localities with ordinances in this regard, and so we're also trying to put them in compliance with the Dillon rule as well. The number of accidents and deaths nationwide that are caused by distracted driving are increasing in alarming rates, and we have seen it in my county, which is why Fauquier and Loudon and pretty much everybody in my district has been a very strong proponent of producing something that has a little bit more teeth to it this session. So the committee moving forward with something would be a vast improvement And I just want to thank the committee for their time, and hopefully we can move it on through.
Delegate, I assume that they
Yes,
would
sir.
not mind if other counties were, I'm not being funny, but this would be a
No.
state by law, as long as it gives them some action in Buck here, they don't mind if it applies to the rest of the state.
I don't think so.
See,
I'm pretty sure if it applies to everybody,
As long
I
as
think
it's fine.
everybody would be pretty happy with it.
Got it. Okay.
Thank you, Mr. Chairman.
Thank you very much.
Yes, sir.
Hello, good afternoon.
Welcome.
Welcome, thank you. I too support Delegate Collins' bill, but I would like to add that I would support also Virginia going into a hands-free, making hands-free, the texting law, hands-free here in Virginia. Virginia has gone through a couple different stages. 10 years ago, made texting while driving a secondary offense. I just want to tell a personal story. In 2011, there was a case in Fairfax County where Kyle, 18-year-old, driving from home, from work, ran out of gas, pushing the car up the road. Kyle was struck at full speed, killed instantly. The driver's cell phone indicated that he had been basically texting. The court found that he couldn't be tried on reckless driving. Texting was only the secondary offense. In 2012, texting while driving became a primary offense. The problem that has arisen is that law enforcement can't figure out whether someone is texting or making a phone call. You can't convict anyone unless they confess. The law essentially is unenforceable. Current law passed in 2009 must be updated to address the advancements in phone technology. Studies show that using a phone while driving increases the risk of crashing by 70%. The National Highway Safety Traffic Administration reported that in 2015, there were 3,477 people killed. An estimate of an additional 391,000 people were injured in motor vehicle crashes involving distracted driving. We know it's illegal to play Angry Birds, order food, or do anything else on a phone besides sending someone a message. 16 states have decided the best way to deal with this from both a safety and enforcement point of view is to ban having a phone in hand completely. Virginia Tech's Transportation Institute says an average the average that it takes a driver's eyes off the road for 4 miles is that equated to a football field. Driving deaths have been up year after year for the first time in 50 years. I would also like to share that we have the Drive Smart community that sent an endorsement of the bill that I presented, even though we know that it's going to possibly be combined. And they highlighted that their current law, also passed in 2009, is antiquated and must be updated. And that studies show that manipulating a phone while driving increases your crash risk by 2,300%. Making a handheld device while driving is likely the cause or factor in most crashes. We support taking the phone out of the driver's hands and eliminating that deadly distraction. And that would be all, Mr. Chairman.
Thank you.
Thank you.
Okay. So again, we have a number of ideas before us, and rather than take them up individually, what I would like to suggest would be if you are here to testify on any of these bills, now would be a good time, and you can testify about the specifics of the bill, testify about this issue generally, tell us some things you really want to see, tell us some things you really don't want to see. You're welcome. This is kind of a little different. It's a one we passed last year. It's a work zone bill. Let's hold on one. Let's get real public, if you will. He's paid to be here. Yeah. Okay, so I actually thought that I see a lot of people here to testify about something, but I guess it's not this bill. These bills? Okay, great. Please, come on up. Tell us your name, tell us what you'd like how you'd like to see the law change. You can be as specific as you wish, but don't feel the need to be the lawyer if you're not. Go ahead. Yes, ma'am.
We were confused, I'm sorry,
That's fine.
Mr. Chairman.
Yes, ma'am.
Members,
Not too fast. Tell us your name.
Janet Brooking with Drive Smart Virginia, and we support the strengthening of this law. There are clearly a number of different measures before you all today, and we trust that you all will use your expertise to pick the one that needs to move forward and the one that can move forward most effectively, and we are here to serve as a resource if we can help do that.
Tell us, but don't leave. So we have a lot of ideas
Yes.
presented for all of these various bills. Are there things that you think are especially important to include or important that to not have there?
Sure.
Everybody wants safe roads.
Yes, absolutely.
But the issue about hands-free versus texting versus a GPS carve-out versus people mad that people are being pulled over for no reason versus, all of these are things,
Sure.
this is not our first time through this issue.
Right. So I think that, and we have been dealing with this since 2009, and you all have been dealing with this since 2009. So we're of the mindset, and I think that law enforcement is very much on board with the fact that in order to be effective, this needs to be a handheld ban. So that is the only thing that's going to give law enforcement the tools that they need to be able to enforce this law. We've tried for years to kind of work around that, and just really have not been able to do anything that would be absolutely effective. Another thing that we would suggest is that the penalties could be higher on this. At this time, it's $125 and $250 for second and subsequent offenses, and we do believe that that could be stronger as well.
Good afternoon.
Good afternoon. My name is Christina Dixie. I am a firefighter paramedic in Northern Virginia, so I spend a lot of time on the interstate. I'm also the founder of Free Ribbons for 3 Reasons, losing loved ones in a tragic auto accident. In 2013, I lost my sister and both my nieces due to a distracted driver. So I'm in support of all these bills, just like Ms. Janet had said earlier, to get them to combine together to make our law stronger and make our roads safer. In my opinion, I would feel that it would, help prevent families from going through what ours go through every day. Even though it was almost 4.5 years ago, it's still bothersome, and I still run those calls on the interstate where the distracted driving has become increased even more. And it can be anywhere from a fender bender to a minor or major injury to death. And I think that our roads need to be safer for all of us and our loved ones. Thank you.
Thank you. Yes, sir. Tell us your name again and tell us your thoughts on these measures.
Mr. Chairman, it's Bud by Virginia Bicycling Federation. We've been supporting this right along too, and I tend to agree with Janet Brooking that the main thing that needs to be done is to eliminate the use of handheld. We have tried to get all the way around that and carve out all kinds of playing of games and other things, and there's just too many exceptions involved here. And if it's going to give the law enforcement any help at all, I think you have to carve out, or you have to get rid of handheld for the drivers. So we're all in favor of that.
Okay, thank you.
Hello.
Yes, sir.
I'm Brantley Tyndall. I'm with the Richmond Sports Backers. I'm also here to very much echo what Janet and Bud and I forgot the lady's name have said about really prioritizing the hands-free aspect of these bills and the effort of these bills. Part of it is that, and it was mentioned by some of the other delegates, that it's really hard to enforce because when a law enforcement official sees someone with a lit phone screen, do they know, are they texting, are they Facebook or watching YouTube? It's actually perfectly legal to watch YouTube while you drive, which is kind of crazy. I'm also, so I work for a nonprofit that is, we grow the active community in the Richmond region. We touch about 250,000 people every year in terms of paid event registered volunteers, their families, and spectators. And people look to us to make biking and walking safer in the Richmond region. And over the past few years, with developing technology, with ubiquity of phones, you're seeing much higher rates of phone use while driving. And as part of my work with Sports Backers is I teach people how to drive better, how to walk better, how to ride their bikes more safely and more compliant with the law. And when you say that it's not illegal to use phones, just sort of across the board, it's really an education barrier. And I think you're probably seeing that with DMV as well, who fund some of our educational opportunities. So it's hard to enforce it. It's hard to even spot, like, how does a phone look different 30 feet away if you're texting or something else. But we also can't teach people the best way to use their phone or to not use it. So thank you very much.
Mr. Johnson, delegate reminder, just to let the witness know, 46.2.10.77 says no motor vehicle registered in Commonwealth shall be equipped with, nor shall they use therein a television receiver. The moving images are visible to the driver while the vehicle is in motion.
Thank you for that.
So I'd like you to
Where's the code section? Okay, any other member of the public like to be
couple more
Oh,
people.
yes, please, please, come up.
They want to speak on Delegate Weber.
That's fine. Thank you.
Hey, good afternoon. I'm Sheriff Mike Chapman in Lyon County, Virginia.
Nice to see you, Sheriff.
Good to see you. I appreciate the opportunity to speak before you all. I'd like to support Delegate Weber's bill with regards to allowing local jurisdictions the ability to develop their own ordinance that's less than a reckless driving charge. Right now in Loudoun County, we border Fairfax, Prince William, very busy area there. We face a lot of traffic accidents up there. And if you look at 11 jurisdictions in the Commonwealth of Virginia already have some sort of failure to pay full-time and attention law that they write tickets for something less than reckless driving. We don't have that. We actually researched this with the Attorney General's office, and he reaffirmed an opinion this November the 15th that had come out in '79 and in 1986 that says that any local ordinance that is not in concert with the reckless driving statute is a violation of the Dillon Rule. And because of that, these 11 jurisdictions that have it, Fairfax, Arlington, Alexandria, Prince William, you name it, they're all in violation of the current state code. We'd like to actually have that aspect lifted to allow local jurisdictions to do that. Actually would codify what they were already doing and what they've been doing. Fairfax has been doing for over half a century. We want to have that ability because we handle a lot of minor traffic accidents that don't justify a reckless driving charge, so we're left with one of two options, either write reckless driving or nothing at all. And we'd like the opportunity to write something less than that, that may be a prepayable fine, that would get notification to the DMV with regards to the charge itself. And people would prepay it and not show up in court, and they wouldn't get points on it. So it would just be a local ordinance that would allow us the ability to do that without writing a reckless driving charge, but then forces a judge to have to forces you to have to go to court, forces a judge to have to make a decision and reduce a charge, which is obviously going to be reduced anyway. So we'd like Delegate Weber's bill on this, and would appreciate your serious consideration on that.
Thank you.
Thank you.
Mr. Chairman,
Delegate Klein.
just a question for the sheriff. Thank you
Yes.
for being here and for all you do to keep us safe. Do you have any concerns about the possibility of patchwork developing from locality to locality where drivers are having it?
No, I actually think it's important to recognize that there are certain areas that are much different in the state than other areas. And if you look at our area there, we're very highly populated in Northern Virginia. And what applies to us may not apply to other localities in the Commonwealth of Virginia. So I think it's important that we have the ability to handle this in a more reasonable way, rather than writing reckless driving charges that have been on the books forever, and then having to force people to go to court rather than just writing them something smaller that they can prepay, not show up, they accept guilt for the fine for the traffic accident, and they move on. So I think it's important.
Further question, Mr. Chairman.
Delegate Klein.
Wouldn't you agree that if you began writing these as reckless, you would get the attention of your citizens?
That's very unfair to write somebody for a very minor traffic accident for a reckless driving charge, which forces them normally to hire an attorney, which is rather quite expensive, to come to court, to have to go before a judge, to take a day off of work, and to pay a fine, and not only pay the fine, but usually to pay the difference with it's unfair to charge somebody with something that serious and what's a relatively minor traffic accident. I understand if it's a reckless driving and it's a wanton and willful disregard for the law, for the driving statute, but it's certainly quite different where somebody just fender bender somebody, a taps a fender, and ends up getting, believe me, I've been on these and I've seen them, and it's absurd to write somebody for reckless driving as something that's not really a reckless driving
Well,
charge.
Sheriff, let me further question, Mr. Chairman, then isn't it current code that failure to maintain control of your vehicle is reckless and can be charged as such?
No, you can't be charged as such. You have to charge reckless. It's got to go down. It's got to go before a judge. It's got to go. What I'm saying is that it would be nice for deputies out there and for law enforcement officers across the board to have the ability to make that distinction between what they see as a reckless driving charge versus what's not a reckless driving charge. Right now, it doesn't give the deputies or law enforcement officers any latitude, any discretion in making any decisions out there. We've got to write for reckless, and then it's got to be reduced. We make life and death decisions every day. I certainly think most of our law enforcement officers out there can make a distinction between what's truly a reckless driving charge and what's improper driving or distracted driving.
Thank you, Mr. Chairman.
Thanks, Sheriff. Anybody else like to testify?
2017, there were 6,499 crashes that were reported involving drivers who were using cell phones or texting while driving. Of those crashes, 3,643 people were injured. 457 of those were serious injuries, and 48 people died as a result of those crashes. Additionally, 6,000 in the same time frame, 6,163 people were convicted of texting or emailing while driving. That's all I have for you.
Let me have a question. Now, this, you said 649 of the crashes were traced to that. What happened in those? Were they charged with other charges, or were they not charged at all, or what happened?
I don't have any additional statistics with regards to those. And I'm not 100% clear of those convictions. I know that that's the stated number of convictions for that time frame. I don't know that they were directly associated with the crashes.
Convictions for, sorry, Mr. Chairman.
I'm just asking. If you're convicted for reckless, I think that was some. You do not know what happened in those crashes. What charges arose, or the charges led to convictions.
I do not.
Mr. Chairman,
Delegate Klein.
you said a certain number of convictions, is that correct?
Yes.
Okay, convictions for what?
Texting or emailing while driving.
Okay, so the texting statute.
Yes.
Um,
That's the total number of
Okay,
convictions for
Mr.
that time
Chairman.
frame.
Question,
Delegate
State Police. So, really, it's up to each jurisdiction to really decide whether coming upon an accident, single car or multi-car, they determine who's at fault, whether or not to charge reckless driving under the failure to maintain control statute, correct?
It would be the investigating officer's obligation, and if he had sufficient information to place a charge of that sort, then certainly that would be up to him and his discretion to make that charge.
And once brought to court, those could be reduced to improper, correct?
That's certainly within the purview of the court.
Thank you.
Okay.
And then lastly, I'd like to point out that the department doesn't take any position on the bill. Thank you.
You said 6,153 convictions for the current statute. Is that right?
6,163.
63. Gosh. Okay. 12-month period. What, a year? Is that over a year?
No, that was between 2014 and 2017.
Okay. Okay. Thank you.
You're welcome.
Okay. I've got some questions for staff to try to get us on the same knowledge page. Are we ready? Mike, you come up to be part of this. So, you got a statement you're going to make, and then you can stay up there while we.
Certainly. Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of College Attorneys. And first of all, we're not taking a position for or against either any of the handheld device bills. Our concern is with Delegate Weber's bill. And if I apologize, if there's been an amendment in the nature of substitute, but I'm not aware of one. The bill as introduced, though, gives us a lot of pause. And the pause is outside of the fact that there are jurisdictions that are in violation of Dillon's rule and they want to get in conformance with Dillon's rule. The bill as introduced basically says that failing to provide proper time and attention necessary that does not constitute reckless or improper driving. And I've been prosecutor for 34 years, and I'm not sure what that is. If it's not reckless, I know it's improper, but if it's not reckless and it's not improper, what is it that one is not failing? So I have some concern with that. I understand what they're trying to do here, and I understand the concerns that the sheriff of Loudoun County has, but the way to fix that issue as far as officers showing up on a reckless is to give the officers the discretion to charge improper directly. It's not through this particular bill. Our other concern with it is concerning the fact that the traffic infraction shall not be reported to DMV and not made part of the record. And so these are collisions that are occurring probably on a recurring basis, probably involving cab drivers or Uber drivers or Lyft drivers or whatever, and they're getting this constant distracted driving conviction is not being reported on their DMV transcript, and so the court is not able to take any further action as far as the disposition is concerned. The DMV is not able to take any action as far as their license is concerned, and so we have a lot of concern about that as well. And so, given that, we are in opposition to HB 116.
Okay. I want to get just to put everybody on the same page with the staff. So, Mr. Mutnick, let's sort of go through some big picture things. If someone is driving and kills someone, they would be at least possibly possibly guilty of involuntary manslaughter, if I have it right.
Involuntary.
Yeah, involuntary
And
manslaughter.
what is the criteria for that?
That is the unintentional killing through an unlawful act. Usually involuntary manslaughter would be accompanied by a reckless driving. So it would have to be some sort of aggravated.
Gross
Gross negligence
wanton.
aggravated beyond a reckless driving.
Yes.
If you could state the legal standard on this.
It's the unintentional killing of somebody through an unlawful act. It's gross negligence.
Gross negligence.
It's gross negligence. I don't want to use those words because that's not really
But
It is.
It is. I mean, you could have a reckless driving, you can have reckless driving and a death and not have it being manslaughter.
I'm just trying to actually, there's a bunch of non-lawyers in the room, we're gonna start doing some work, I was just gonna try to lay down. If you act in a way that kills somebody, and it's what? Willful wanton disregard.
Of human life, that's right. That would be
And
manslaughter.
that could consist of some common, the use of the phone could consist of part of that. If you were
Could,
driving for
but
4 miles the wrong way on the road, driving 103 miles an hour while you're.
exactly right. By itself, it would not constitute involuntary, but in conjunction with other acts, it could.
And then the next level down would be reckless. And again, if you were found to be using this in aggregate, you had committed reckless driving, if you could tell us the standard for reckless driving.
Go ahead.
Driving in a manner to endanger life or property.
Okay. And then below that, we have infractions. Now, we had a testimony about a case where someone was killed with a phone being used in part as part of that. Would you not be eligible for the manslaughter charge if the facts warranted it?
The problem is one of proof, it's not one of the legal sufficiency. The problem is one of proof, and I believe the witness talked about how it's hard to tell whether or not they're texting as opposed to talking, as opposed to looking at the GPS portion of it. And that's why there's the cry out for handheld or hand-free devices, so that the officer is not put in that conundrum of trying to prove that they were texting as opposed to using it as a GPS device.
I guess what it would be if somebody died, you would be looking at a little traffic infraction for the phone. You'd be trying to see if you could make a manslaughter case.
Manslaughter, reckless, whatever it might be, yeah, absolutely.
Okay, then a reckless case is punishable up to you're in jail,
Yes, sir.
up to $2,500 fine, or up to a 6-month loss of license, right?
I believe, yes, that is correct. You know, there might be a provision under 46.2 where, because someone died, it's a year loss of license.
Okay, and it wasn't, I was off the death. With death, you have all sorts of other penalties.
That is correct.
Okay, and then we have proposals here that would, in the past, we've looked at making the use of a phone part of reckless, which would make it a misdemeanor, or make it a infraction, meaning it's something we'll charge reckless if they're reckless, but if they weren't driving recklessly, but we're still using the phone in a manner we didn't like, we'll treat it as one of the traffic infractions. Is that basically right?
Yes, sir.
Okay. All right, and the freestanding code section that we currently have, we're told is about 2,000 convictions a year. Does that in any way preclude any of these other charges if something worse happens?
No.
That's just driving by and you see it, but if you come to an accident and think it was recklessness, you can still charge with reckless.
Absolutely. We were looking for things like speed, those sort of physical indicia of something in addition to use of a handheld device.
Okay. So that's sort of where we stand. Now, Delegate Collins, you have been, I think, making the rounds prior to today.
Yes, sir.
Okay. And again, they're reckless. We don't need to cover, it's reckless. We've got reckless.
We haven't changed that at all.
Oh, okay.
With the amendment 181 you have in front of you does not address reckless driving at all.
Okay. And it doesn't invalidate an involuntary or voluntary manslaughter charge if the facts
Correct.
warranted. So if someone's driving high at 100 miles an hour and using their phone could become part of the case for manslaughter if we get a death.
That's
Okay.
correct.
So this is that remaining category where they are not doing those things, but using the phone.
This is the category of the individual who is trying, and when I was a deputy sheriff and they told me to go run radar in the neighborhood and I was writing more tickets for people living in the neighborhood, the person driving down the road like this, looking at their phone or looking at their lap, or now there's devices on their steering wheel that they can attach so we have the substantially diverts the driver's attention. So for a law enforcement officer, obviously there has to be a observation of the driver whose attention is being diverted.
Okay. Now, for the most part in traffic law, we do not punish until you run the stop sign
Correct.
or the stoplight or run off the road, hit a tree, or hit some, other some extent, this is prophylactic, right? Is that,
It is. I mean, for example, unless you're being witnessed using your phone, then it's a difficult.
I'm asking the question back.
Okay.
We don't really care about the phone for phone. What we don't like is we think it's distracting you from driving down the
Correct.
road, right?
Where the texting while driving, the failure of the texting while driving statute is now is it is only for texting. So an individual could go to court and say, I was not texting, I was FaceTiming on Facebook. Okay, well that is not texting. And so therefore they could not be convicted of that. And unless there was driving behavior that was of reckless nature, or was endangering life, limb, or property, there was no criminal charge. There was no traffic infraction or other charge that an officer could bring, unless of course he was in an accident. So that individual who is who's driving down the road, talking on the phone while videotaping themselves, officers were left with nothing to do unless there was significant harm done. So as Lieutenant Gosnell told us Monday when he came and spoke to us individually, it's like watching a guy at a bar stumble out, get in the car, know he's drunk, he's driving erratically, and you have to wait till he wrecks the car before he can charge him with DUI. And this, of course, stops that. So now you have a rationale for a traffic infraction.
Okay, so walk us through your language.
So obviously, any person who drives a vehicle on the highway, I think everyone here knows what that means, that does not endanger life or limb. Obviously, that's language that is separate from the reckless driving statute, which in fact does have endanger life or limb or property of another. But while using a handheld communications device, which there is no definition for handheld communication device, we do not have it in the texting statute either. So that is for the trier of fact to determine whether that's going to be left up to the trier of fact, or such use substantially diverts the driver's attention from the operation of the vehicle is guilty of distracted driving, period.
Okay, stop or pause. Okay, so the issue that will come up before the courts will be to demonstrate that their personal communication device has substantially diverted the attention, right?
Sorry, sir. That's the question.
I'm just walking through it. So, handheld personal communication device, what does that cover?
That is from what we have worked with counsel, and I think we've worked with a lot of the other individuals. That covers just about everything. Now we do have some exceptions, but I don't want to muddy the water.
What's that?
Mr. Chairman, that's the current definition in the current texting law 46.2.10.78.1.
Okay.
Mr.
Yeah,
Chair?
since phones and texting have kind of merged together,
Correct.
I mean, it's going to cover. Go ahead.
Just reminding, we had a lot of this discussion last year when we had Delegate Marshall's bill involving cell phones that we were trying to get into this definition. This is sort of where we fall into again last year as well.
Okay. He's guilty of distracted driving, substantially diverts. Okay. And then, oh, I'm sorry. Okay, then what we then is have some opt-outs on the other side.
Yes.
Okay.
And there's specific opt-outs that actually exist currently in the code.
Okay, so it does not include factory installed feature or function of the vehicle. Okay, now we have had some other patrons talk about what I'll call Bluetooth, what they call hands-free. And hands-free, I guess, could be a speaker set up through the vehicle, or it could be I use Bluetooth. But
I have the earpiece Bluetooth as well.
okay. So this does not have a safe harbor for a hands-free device. Something stricter than that.
It's a little stricter than that because it does say that if it diverts your attention. So for example, I think that if you probably are more apt at using your Bluetooth piece than I am, so you probably push the button and not distract your attention. Whereas I do it and my phone and the thing aren't linking together, and so I start looking at the phone to see if I'm blinked up. That is distracting their attention. So now my attention is distracted.
Okay. Let me ask staff. So this uses substantially diverts. We use substantially throughout the code. Is there a definition of some sort? Or is it just case law?
It's just case law defined, Mr. Chairman. It's used 518 times in the code. It's 11 times in 18.2 and 11 times in 46.2.
Just try not to create new words. Okay. Does not include a factor installed feature or function of the vehicle. Any feature. And then you have your exceptions. Provisions of the section not apply to the operator of an emergency vehicle while he's engaged in the performance of his official duties. What's an emergency vehicle?
Chairman, that's defined in 46.2.9.21.1, also in our current texting law. There's 7 definitions of emergency vehicle that is defined in the code.
Fire and rescue?
Any law enforcement or vehicle operated in the direction of federal, state, or local law enforcement, regional detention center vehicle, any vehicle used to fight fire, any emergency medical services vehicle, any Department of Emergency Management vehicle, any Department of Corrections vehicle, and any vehicle authorized to be equipped with alternating, blinking, or flashing red and white secondary warning lights.
An operator who is lawfully parked or stopped. That you wouldn't have that because you're not driving.
Correct, but it was something that was in the texting statute as well. So if you pull off the side of the road.
I'm saying we don't need it because
We don't need it, but
we can't. I mean, we don't need it. It says any person who drives a vehicle, not operates a vehicle. So. Okay. So stopped, not. Is that driving? I thought you needed movement. Staff, you know what I'm talking about. It doesn't. Driving suspended requires driving. DUI requires operation. The court's been very clear that they mean different things. I thought driving meant the wheels are rolling.
I think the concern here was you stop at a stoplight and you pick up your phone to make a call or do whatever. But then once you start again, it diverts your attention. So I think that was the purpose of the idea here.
I'm not adverse. I'm just trying to avoid contradictory sections. In other words, this talk about being lawfully parked. But it looks to me like if you pulled off illegally and parked, you would not be covered because you're not driving. You're simply being legally parked. But Steve, do you have a? Okay. I'll keep going. Roman at 3, an operator using a handheld person computer is advised to report an emergency. So that's when you call 911.
You're behind a DUI, you call 911, you're on the phone trying to get their location.
What's an emergency? Because I don't.
What is
what
an
you
emergency?
just said is something I would think would be good, but that's not an emergency. That's making a report to a.
I think that I have seen that has been in fact an emergency, not for this particular code section, but obviously to report. Yeah, it's in the texting statute, I believe.
Number 4, an operator using a handheld radio-based communications device for emergency or disaster relief operations. That's a ham.
That's the ham radio operator's language that they would like to have when they're operating during hurricane relief or such.
Okay. And then it's punishable as a traffic infraction, punishable by not more than $500, which is the same as the improper.
Correct.
Now, it doesn't really have to tie to improper anymore since it's a freestanding section, right? It's not
Correct.
lesser included from reckless.
This is a standalone provision that can be written as its own citation by law enforcement. And it'd be a summons, obviously, if they have that question.
Okay. Mr. Monick, do you have that?
Mr. Chairman, the definition of drive is the process of moving the vehicle from one place to another. The process of moving the vehicle from one place to another.
It's not the same as moving the vehicle from one place to the other.
It's not. I think that if
That's right. It's existing code. We could go on. Okay. Okay. So that is the go ahead and talk about it some. And we have another meeting on Friday, so if there's some significant changes to be made, other than just no matter what you do, I'll never vote for it. We can send Delegate Collins and make sure he comes back on Friday. But conversely, if we love it exactly as it is, of course we can vote. If we will never vote for anything, of course, this will save everybody's time.
Mr. Chair?
Delegate, I heard. Happy to defer. Let's start with Harry, and then I'll go back and forth.
I'll just be brief, and it's for the patron, because that part substantially diverts attention. I would think that would be not an easy defense, but someone to say, well, I was diverted, but it wasn't substantial. Like, so, is that gonna be?
Law enforcement raised that issue with me as well. I've raised it with staff, but because we use substantially in a number of places in the traffic infraction area, I think, and I would probably divert to those who, I haven't written that ticket in 20 years, I would divert to the people that have done it recently, if they think that's an issue. Or prosecutors who think that might be a problem prosecuting.
Oh, okay.
This would be a good time to invoke, there's something called the Albo rule. Dave Albo was the chairman prior for a long time before me. And the Albo rule goes as follows. It's always easy to get the guy you're thinking of right now as the bad guy. The hard thing is trying to get that guy without getting a bunch of people you don't mean to. So for instance, a one sentence version of this bill could be, you may not have an electronic communication device in your car. That would catch every single one, it'd be very easy to prosecute, and every single person we catch would be guilty. I'm not aware of anybody actually proposing that, but that's, if you're wondering what this, now we're gonna start sorting through, is trying to figure out, this gets out in the field and gets applied, who we actually getting, who are getting, we need to be, that kind of thing. Okay. Delegate Mullen.
Thank you, Mr. Chair. I think I have a question more for staff than for the patron at this point. So my own bill that alters involuntary manslaughter and sort of creates a presumption based upon the use and operation of a handheld communication device. How would this statute that were proposed by Delegate Collins interact with the involuntary manslaughter statute at this point? Would that create any additional presumptions or liabilities there too?
Mr. Chairman, if I may, I'm reading in this bill, the reason that the language does not endanger the life or property was included was to accept it from the reckless driving, but also basically say that this is the lower version of it. If somebody's out using their phone in a way that does endanger life or property, they're guilty of reckless driving. If they use a phone in the way that is gross negligence, basically, then they're guilty of they could be guilty of involuntary manslaughter. There obviously would need to be more evidence than just the use of the phone. I think that would be the state of the current law as well.
And quick follow-up as well, Mr. Chair. So under current law, if one were to be operating a motor vehicle while using a handheld personal communication device and it somehow interferes with the operation of the motor vehicle already, that would, in theory, already be covered. So what we're covering now are actions that don't interfere with the operation of the motor vehicle, but could, in theory, do so by their inherently dangerous nature. Is that right?
Mr. Chairman, I think that if under current law, using a phone in some instances would not even be illegal, as it's been pointed out as well already, but if you use a phone and it causes you to not be able to operate your vehicle in a safe manner or in a way that endangers life or property, you can be guilty of reckless driving. In fact, there is a section in the reckless driving penalty that includes a mandatory minimum fine if you are using your phone and driving.
So what this means is that we're no longer talking about somebody who's swerving out of lanes and slowing down or going too fast or something like that. Now we're just talking about somebody who's just operating their phone without any other additional.
Mr. Chairman, it's an attempt to get to that behavior before it. I would say before it becomes reckless driving.
Thank you.
Delegate Klein.
Okay, so we have the reckless driving statute where you're endangering life or property. We have the texting statute, which doesn't really speak to that, but proving to be ineffective or less effective than it could be. But the issue that we're talking about here, I mean, we all wouldn't be here. We all wouldn't be introducing bills. We all wouldn't be talking about giving very gripping stories about people losing their life if this wasn't an activity that was dangerous to life, to limb, to property. So by going down a road where we create a statute and we state that this activity is not, I think is counterproductive. I think that, I've always kind of come at it that reckless covers this. And if we need to go into the reckless statute, into specifically 863, which says that, can council read 863 to me? 853.
Mr. Chairman, 462-853 states a person shall be guilty of reckless driving who drives a vehicle which is not under proper control.
Okay. Not under proper control. It also talks about brakes being faulty as a secondary. So my initial approach to this 5 years ago, I can't remember how many years ago it was to say 853 was actually includes using a phone to text. And I'm just not, I think that reducing it to improper, maybe even removing the prohibition on charging improper may be a better direction to go if you want to start having a lesser than reckless level offense. But putting an additional type of, additional standard, distracted, I think, in between improper and reckless is going to confuse and is going to, I think you'll have fewer charges of reckless when they might be warranted. And I like the idea that you're repealing the existing statute. I'm just not sure that this gets us where we want to be. But I'd like to hear the patrons' kind of thoughts on that.
I think Mr. Cotter has something he wants to show you first.
You can show me Anderson's from last year. Yeah, it was aggressive.
Delegate Adams, did you have something you wanted to say? I've got some thoughts, but you don't have to.
No,
Everybody seems to be. So, I would say that my thoughts on this have changed some over time, and part of it is just the nature of this ongoing problem. Generally, in the I'll just speak for the public, I guess. Generally, in the traffic section, we don't try to address things before the bad thing happens. We see people, as we always used to have these long discussions, all the other things that distract people as they drive. So, you eat, and you, DUIs. We eat, and famously people are staring into the mirrors, and you're changing the radio or putting on this, we used to use CDs, put CDs into the device. All of these things, the kid is screaming in the back, you're yelling at your best friend who's in the front seat. All of these things are very distracting, and none of them are chargeable. In fact, I can't recall, until there's an accident, until something bad happens. And then we say, we don't really almost care why it happened. You caused an accident. You're such a bad driver, you hurt somebody, now we're going to charge you with reckless and all these other penalties. And then occasionally we see something like DUI, where we don't care if you're driving perfectly down the middle of the road. We are so worried about the lack of safety that we're going to come up with a prophylactic law to address it. Speed. We ultimately address speeding because we think speed differentials make it very hard to drive safely, and if you're driving so fast, obviously your reaction time is harder to stop in time in case something bad happens. And like Delegate Klein, I've been here for about 16 years, and we still have this problem. Now, I don't want to overstate what we can do here. The truth is, if the majority of Virginians want to do something that is unsafe, we will nibble at the margins, and over a 20-year period, bit by bit, get there, and society will change what's acceptable. That's what happened with DUI laws. It wasn't the laws we wrote. Those, I think, helped. But ultimately, people decided that driving drunk wasn't cool, and it's unsafe, and their friends got killed, and now people say, I'm not going to let you drive drunk. That's where we have to get to on distracted driving. And I'm not by any means saying that I'm that guy who never does this. I'm not trying to put myself above anybody, and I don't hear that from any of the people speaking up here, and I don't hear from the patron. So this would be a different step. Because the reckless steps we talk about is only when the officers observe something all over the road, or even more than typically, I think, when they come up and you're rear-ending somebody or up against a tree. This would be an effort to try to find some balance where we say, even though you haven't hit somebody yet, even though you haven't caused the accident yet, this driving is so unsafe that we are scared that you're going to do something. And Delegate Klein is right. We have tried 3 or 4 different approaches. This would be another approach. It would then depend on enforcement, and we haven't yet heard, there's people in this capital who will hear about this and very quickly say, and now you're picking on certain people. You can charge almost anybody with a crime, that's not right. You're going to use it to pull the wrong people over. That kind of thing. I haven't heard that today, but it's coming. So, Delegate Collins, I guess I do come to the notion, I've come around on this. Delegate Gilbert's not here, but I think he would be open to some offense that says not as bad as reckless, but we really think this is something that is fundamentally unsafe, and try to find language that covers it. And I'm not sure we're there yet, but it seems like a good place to start. So I'm not somebody saying don't keep working. I do think there's something to work with here. I don't want to speak for everybody, but yeah, I guess that's what I'm saying. We would.
Can I respond just briefly again? I just want to reiterate, I think something we've already talked about here, and that is that we have law enforcement who will, the analogy, we use the DUI analogy, that we have law enforcement sitting in a parking lot watching people stumbling out of a bar, and if the only time we can charge them with DUI is after they hit somebody or wreck into a ditch or hit a tree, and that's the probable cause, that's what reckless driving is. And I think that's the barrier for a lot of courts and a lot of judges, is that there has to be something that actually happens, an affirmative action that happens with the driver to be charged with reckless. This now is more of a probable cause DUI stop. They cross the fog line, or to use that analogy. So now we have something that might actually prevent the accident before it happens. And so I don't disagree with Delegate Klein's points on this, or the chairman's issues on this. However, it is an issue that I think that if texting while driving, and whether or not using phones while driving, and being distracted while driving is something we want to enforce, I think we have to give an affirmative to law enforcement rather than reactive. Thank you.
Okay. You're a member of the sub, so we're about to.
I like it.
I hope so. So, what we sometimes do, everybody, before we have somebody do work, is we call it taking the temperature. It has no legally binding force, but sometimes we talk for 45 minutes and nobody likes the bill. I don't know that that's here, but if that's true, then we can save Delegate Collins a lot of work, and then we would follow it up with a vote. If the temperature is keep working, then my suggestion would be come back Friday after you start to talk with everybody one more time, and we'll come back and have a final vote. So let's just take a temperature. Who thinks that there's a bill out there that if everything aligns and you like it, you can vote, and how many thinks that this is a dead end? So how many people think he should keep working on this? Okay. All right. Go ahead. All right, everybody, thank you for your time. We're going to carry all of those bills over to the next meeting. To the other patrons, the intention is to come up with a single vehicle for this, and people that want to co-patron can talk to Chris about it. Delegate Collins, do you have something else you want to say?
Delegate Yancey's bill is a standalone driving through a work zone.
Okay.
He was sitting here waiting. I just want to make sure that didn't get sucked into the
we'll
black hole.
get him back here.
Okay.
All right, Delegate Hope, you're back. So we were trying to do your bill without you. I understand you have a birthday to get to, and then the deal was if we had any issues, not to.
No, I appreciate the courtesy, Mr. Chairman.
All right, so and it looks like a simple bill, not an easy bill, but a simple bill, meaning it applies this test to.
That's right. This applies this test, expands it from simple marijuana possession, expands it to misdemeanor distribution of marijuana.
Okay. Delegate Adams, I think you wanted to address some issues, or.
I'll ask for my co-counsel, Mike Doucet, to come up, if you would. This was brought to me by our Commonwealth attorney in Arlington.
You may be fine, I don't know. We wanted to stop before we.
Absolutely. This one goes down, I'm not bringing any more drug bills anymore.
So you're being appointed to come sub. I'm sorry, whatever we're calling it now. Okay, so Delegate Adams, do you want to ask him something, or? This was the one we did. It wasn't. We could redo it if you wish. Yeah, it was presented by Monday. Yeah. But everyone.
I need to hear about the bill.
Sure.
But.
No, of course. House Bill 88 allows the Commonwealth to rely on field test results in trials involving misdemeanor charges of possession with intent to distribute marijuana and distribution of marijuana. This change creates the same testing procedure for all misdemeanor marijuana cases. Current law allows field tests for marijuana possession, and there's no reason to believe that the same drug should not be subject to a different testing requirement. It would reduce the drug analysis caseload at the Department of Forensic Science. This types of cases consume about 3,000 a year for them, so House Bill 88 would allow the department to focus on testing felony drugs and large weight marijuana distribution. Anyone impacted by this change would still be able to request a laboratory analysis. Again, it does not apply to felonies, we're just talking about misdemeanors. And again, the big thing is also reduce the caseload for the department.
Okay. Anybody have any questions for the patron? Delegate Adams.
So, again, we're just trying to catch up a little bit here. Essentially, this is going to make a field test admissible in adjudicatory hearings for all misdemeanors.
It's for misdemeanors and for charges of possession with intent to distribute. That current law is misdemeanor,
Right?
and this is expanding it to possession with intent to distribute.
Okay. Misdemeanors already
For
is the case. So, for possession with intent.
Mr. Mudnick knows the answer.
Mr. Chairman, Delegate Adams, this current law is for possession of marijuana cases. The field test can be used. What this would do would be allow it in a misdemeanor possession with intent. There's two levels of possession with intent. There's felony, which is greater than 1/2 ounce, misdemeanor less than 1/2 ounce. So this would be to expand it to be allowed in that, but it is only in misdemeanors. Any misdemeanor, any other drug misdemeanor, like possession of Xanax, would still require a lab.
Follow up, and you to say that defendant would be entitled to a certificate if he requested.
If they wanted to have a lab test, they could request that. Doesn't take that long.
Okay. Anybody else have any questions for the patron? Any of the public like to be heard on this bill? Do you? Yes and no. Okay, go ahead. Yep, like this be said.
Like I said, Executive Director of the Virginia Association of Council Attorneys, and we do support the bill. As pointed out, these field tests are already in use for simple possession of marijuana cases. Our conversations with DFS are that these are very reliable tests. More so that when this bill initially came up as far as simple possession is concerned, this is the one area where they felt confident that these were able to sufficiently and accurately identify marijuana as such. The others is we are able to use, for instance, a field test for cocaine, but only in a preliminary hearing because there the standard is probable cause. And so, again, this would allow for distribution of marijuana or possession with intent of marijuana less than 1/2 ounce, which is very few and far in between. I mean, if you had less than 1/2 ounce, unless you admit to the fact that you were distributing, I mean, it's not going to get charged. The other thing is, of course, and this is the important thing, is that DFS right now is so far behind in their lab analyses. We are seeing somewhere between a 5 and 6 month backlog, and this is really slowing down the process, especially for those who are incarcerated pre-trial. And it's leading to an awful lot of problems, and it's really slowing down the process. And as been pointed out by the patron, the person is always allowed an opportunity to have an actual analysis under the law as introduced for these particular instances. And so if they know that what they have is oregano, and then they can say, no, I want beyond the field test, I want a lab analysis. If they concede, basically are conceding, yeah, it was pot, then they don't have to. They could also still request that analysis, but less likely to do so. And so for those reasons, especially speeding up the lab analysis by DFS for other drugs, we would support this bill.
Okay. Ms. Jankowski.
Thank you.
For the rest of the story.
Thank you. Maria Jankowski from the Virginia Internet Defense Commission. I have more of a more concern than a sort of vehement opposition. There's a lot of practicalities here that I don't think have been completely vetted. First and foremost is the way that notice is provided across the Commonwealth. You talk to 10 different jurisdictions and you're going to find that it's done probably in a number of different ways. In Richmond, they provide it at arraignment and the public defender's office is sitting there in arraignment. So the attorney gets the notification, the attorney can put it in the file, and the case can be sort of intelligently determined whether or not that, that full lab analysis is going to be requested. In other jurisdictions, individuals are receiving that notification, I say on the street. It's by the officer to the defendant, and that's fairly typical. That's fine in a simple possession when you're probably getting released on a summons. So you're getting 2 pieces of paper. You're getting arrested on an intent case, you're getting a lot more paper, you're getting booked into the jail. The likelihood that that defendant is still going to have that notification paper and going to keep up with it and then be able to provide that subsequently to the lawyer in a timely manner. This sort of the logistical concerns that I have as far as notice and what would happen in an intent case. Moreover, as far as greatly reducing or impacting DFS, I have to question whether that would end up happening because I wonder how often people are charged with misdemeanor intents or whether or not it's frequently something that's pled down to after it was charged originally as a felony and already went to DFS to begin with. So I don't know the numbers on how many misdemeanor intent charges are actually written in the Commonwealth, but I suspect that they are few and far, you know. And if it's written and you're not trying that case, you're either pleading it down or you're trying it. So I just question that it will have this massive impact on, you know, what's going to DFS. And so it's the notification part that gives me the most concern.
Mr. Chairman? Thank you very much. Go ahead. What is the number on the form that you have to be given when you get a field test that you write to be on a possession charge? Yeah, I'm just trying to think.
The number of,
Yeah, it's like a
DC3 or
it's a DC something.
DC3 or 4, Mr. Chairman.
Thank you. And isn't that required to be given on the scene?
There's no requirement in the code section as how it's to be given. It just has to be given to the defendant before trial.
Prior to trial. Okay, that's the standard.
And I think it's done, and our concern is it's kind of done different everywhere.
Okay. But I think your hunch is probably right. That charging misdemeanor possession with intent to distribute is probably rare. You see it reduced from felony level 1 and up.
Mr. Chair? Mr. Mullen? Just for a question for Mr. Dusak or for Jinkowski. Isn't the practical effect that we see when somebody is charged with either misdemeanor possession or currently that the defense attorney, if they're going to question it, will just immediately ask for it, as opposed to going through the process of wondering whether or not their client kept the form or not? You know, practitioners sort of understand the fact that their clients provided it at some point, but not always.
I don't presume to speak for all defense attorneys.
No, I wouldn't ask you
And
to
I
do
would
that.
suggest to you that the good ones would probably do that. The folks who are less inclined to be effectively represented are folks whose lawyers are only going to get paid $120 because it's a misdemeanor. I don't know. I can't speculate.
Ms. Jinkowski, you do more of this than we do up here, but I do.
Not anymore.
Okay.
I do this.
I mean, sorry.
So much
So
work.
sad. So, I mean, the issue, so I work in Charlottesville. This is not an uncommon charge. We get these from time to time. And the question you ask is there any reason, do you have any doubt that it is? Because if so, you have the right to a lab test. And I do that regardless of whether there's a form. With the default is there's not a form. In fact, it's never going to the lab. That's the default everywhere, and so that's why I ask. And if you didn't use it, try it. No, it doesn't matter if you bought it, doesn't matter if you thought it was, but if you have any doubt, let's send it off to the lab. If not, it costs you whatever it costs.
Because the case might get kicked.
Right. Does anybody have any idea? Is Meredith here?
Mr. Chairman, I can probably.
How many charges there are? Okay. Mr. Collins.
I was going to bring something up about proper practice. I stopped doing a line certificates on simple marijuana when I had a client with a smoking device that tests positive marijuana, sent it to a lab, and it went from a first offense marijuana to possession of cocaine. I'm not sure. So
That was a particular device.
that was a particular device, it's true. But I will tell you from my jurisdiction, the court, when I'm court appointed, the court sends me the form already filled out for just for me to sign if I want to request it.
And that happens in many jurisdictions, but not all.
Lots on our plate today. What is our pleasure?
Mr. Chairman,
Delegate Klein.
move the report.
Second.
Motion made to report this case. Excuse me. Bill. That's right. Everybody cast your vote in the electronic voting board. What's your daughter's name?
Yeah.
Wish him a happy birthday.
Going too fast.
Okay. The clerk will close the roll. Okay. Okay, I'm trying to judge what'll get the most people out of the room. If you are here because you wish to testify on 1257, the Sanctuary City Bill, raise your hand.